for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
I like the Amargosa Valley.
Radio Law Talk. Now back to the show.
You know, in life, I've always learned from one individual that I looked up to, and he said the following: I love everybody. I just love some more than others, and I'm going to make an exception to that. There's some people. There's one person in this world I hate. I just hate this.
I'm
person.
sitting right here.
Yeah, I know you. I know. There's. It's a pure hate. It's a pure hate, and I'm going to put it out there.
I don't like that you look at me when you say
no,
that, Fred.
No, it's pure hate. Is the individual that walks in and brings donuts in. That person is the devil.
Yes.
And if you want to talk about the devil, it's the donut person that walks in and puts the donuts. I'm doing well on my diet, and that donut just called me during the break. And my wife's not listening now, and I had to take a bite. And it's just, I just did it. I sinned.
You're the victim here.
I'm the victim.
You are the victim here,
I am.
Fred.
Who do I
Yes.
sue?
Case or no
the donut,
case.
the donut shop. I'm suing the donut
Yes.
shop.
How dare you be responsible for your own consumption of food? You're the victim.
I am.
And somebody else should be responsible, dang it. Somebody.
That's exactly right. Doesn't that sound like a Seinfeld episode?
I think that you are entitled to no less than $100,000 compensatory damages.
Or free donuts the rest of my life.
And what was it? 10 million punitive because sugar.
But I'll tell you this, if a member of the California legislature is listening, they just got an idea. Hey.
Hey.
You know.
So I had a donut. There we go. Lori Loughlin is hit with a new bribery charges in the college admissions scandal. I'll tell you, we've been talking about this. We got to bring back up the college admissions scandals because what Todd did is he printed out a really cool, it's the Investigations of College Admissions and Testing Bribery scheme, and it's the United States Attorney's Office, District of Massachusetts, has an actual list that you can look at as to what everyone's name is, what the status is, and what's going on. But there's a thing that just popped up, and tell us what they decided, Todd, since you are the former prosecutor for the DA's office in Tennessee and in California.
So
tell us what happened.
With Lori Loughlin specifically?
Yeah, Lori. Let's talk about Lori first.
So as you know, everybody the 51 folks that were charged in this were charged and they've pled not guilty. They're charged by way of indictment and things have been going and a lot of people pled. Now the people that decided not to plead and decided maybe to fight this, like Lori Loughlin, that are taking it to trial, are now having to face enhanced charges because recently, this last week, the prosecutors amended the charging document to include bribery charges. Now, I look at this, my personal...
Federal bribery charges.
Federal bribery charges. I mean, everything in this case being prosecuted on the federal level out of the federal district court in Massachusetts. But the only problem I really have with this is something that Loughlin's attorney pointed out, which is that the basis of the charges that are now added were things that were known to the prosecution and before the grand jury and the indictments at the time the original indictments and were handed down. So this appears to be, look, they have the right to do it. They, the government, have the right to amend to add charges. But it's very hard to escape this idea that they're now trying to penalize somebody for exercising a constitutional right to
have a trial.
And look, here's the flip side to this. The flip side to this is that the prosecution's going to look at it and say, well, yeah, I get this, but here's why we did it and why it benefited people initially. If we have, say, 3 charges that we originally filed, and we don't include these, and then folks want to go ahead and plead to it and get the better deal, then the public never knows. Look, if Felicity Huffman, for example, had decided to fight it based upon the evidence that was there, she'd probably have charges against her for bribery added too, given the fact that you're paying money and wanting to get something.
But here's the thing. I'm agreeing with you on one point you brought up. There's a real serious issue here with our government.
I agree.
going after those people who want to use their constitutional right to take it to trial, and we're going to see what the jury says of our peers. That's all about our Constitution. And the government says, I'm going to punish you more and add on more to you and pound more on you.
So the government looks at it and says, okay, we got two options here when we want to go ahead and start this case. Two options at the get-go before the first indictment is handed down and before the first person is arrested and charged. We can either prosecute or file lighter indictments, allowing those that want to plead to the lighter stuff to plead and not have the additional allegations out there that would otherwise tarnish their reputation, and maybe have a judge look at it and say, I'm not going to agree to this plea deal because look at all this other stuff they did, and pile up. Or we can just file everything lock, stock, and barrel at the front against everybody. Now, everybody looks far worse than what we were really prepared to resolve the case for, and we have to go through and dismiss a lot of counts. Which way do we want to go? Now, my preference is my preference is it really depends on the type of case. Sometimes you want to file it all, and then you just dismiss stuff. The optical problem for the prosecution is the public looks at you and go, look at all the stuff the DA was dismissing here. You know, they filed a complaint against somebody with 12 counts, and they pled to 1. What about the other 11? Oh, my gosh. Talk about your sweetheart deal that they got. When was the last time we heard about somebody getting a sweetheart deal that the optic of it turned out really bad for the government? Epstein, right?
Yep.
You know, he gets a sweetheart deal because of all the stuff that was dismissed. We don't know much about the case, but maybe the case. Maybe
and the Stanford kid.
Yeah, the Stanford kid,
Swimmer.
too.
Yeah.
So right now we're seeing it on one side. It's sort of the Bart Simpson paradox in one episode of The Simpsons. Damned if you do, damned if you don't. And
right.
Which way are they going to go? If they go light, now they're told they're violating or punishing you for exercising your constitutional right by adding these charges. If they go too heavy on the front, then they say, look at the government. They came after Felicity Huffman with everything when all she really did with this. And I've had clients that have been charged lock, stock, and barrel, you know, and we resolve it for this, and they resolve because, oh, my gosh, if I go to trial on all this stuff, I could be facing all these charges, and I didn't do it.
But don't you think it looks a little bit interesting at the timing of this?
Oh, it does.
Oh, those that didn't plead are going to – and by the way, you know, we're looking through the list here. You know, some of them are getting, you know, John Vandemore, 1 day incarceration,
Now,
3 weeks, 1 month.
Interesting. Vandemore was the one we talked about last week that was the Menlo Park businessman, was the first person to avoid any additional jail time.
Right.
What we didn't talk about then was he was actually the sailing coach for Stanford. Right. Okay, so he was the first one that was a coach that didn't get jail time. And one of the reasons he didn't get jail time, when I read a little bit more about this, is that not one person that was proposed to go to the school went to the school. Right. And that actually Stanford benefited from it because essentially a bunch of donations were made, and he just funneled it all straight to the program and let it go to the program. So he didn't benefit.
Yeah, we did talk about that.
Yeah. So
and so he was not. His was more of a victimless crime.
That's right. That's right.
That's right, Denise. Here's an interesting thing, though. On that same point, I ask this, and this is the underlying question of all this admission scandal. And I'm saying this doesn't apply 100% because the admission scandals, like we talked about, is clearly, you know, bribing and cheating on the ACT. But the question always is out there: should a parent, their children, have preference if they write a fat check to the university for maybe, let's say, an engineering department? I'm not going to say
what some sort of charitable donation.
I'm telling you right now, I know an individual family that has written multi-million-dollar check in the tens of millions for a new engineering building. Should their son have preference at that college? Interesting. There's two arguments, Callum, before I get to it. Oh. The argument is absolutely they should, because that benefit is benefiting the community and the university as a whole. The negative part is, the rich people are going to be able to stand up and get more than the not so rich people. And I guess my argument on that is not so true. Some of the people who have money, their kids can't get in, and because of, you know, admissions rules and certain, you know, we got to have this economic what's the word? Economic
advantage.
No,
benefit.
no, the people in the lower economic are going to want their kids
yes,
should get
yes.
in,
Exactly,
or
yeah.
some, so they do a different scenario. I
Well,
mean,
so
that's
so
what,
here's
so I'm
the
trying to get at it. Since it's unintelligent.
here's the difference that I see between that and this. We can come back is if somebody does that, at least you can go somewhere and see on the books where it happened. So really quickly, yes, if somebody goes and looks on the books, they say, this kid got in and they made a donation to the school, and there's a ledger about the donation that was made to the school. They know who made the donation. They know where it was. And then you look at the conduct that these people engaged in. And maybe when we come back, because we're running out, I want to go over what I discovered about what Felicity Huffman. Now, this is the person that arguably, in terms of kids that got into school, was the one that did the least, paid the least amount to get the kids into school, and engaged in the least culpable conduct, even though it was still culpable. And it was still, when you look at it, pretty bad when you look at what happened. Okay?
They're going to be back. We will be back
So-
in a few seconds to talk more about this.
You're listening to RadioLawTalk.com. And now back to your host, Frederick Penney.
Huffman's sentencing memo, Todd Cunin has been able to get through his little dirty hands, and he's been reading it and studying it about kind of a little bit more of the behind the scenes of what's going on. It sounds to me and all of us like, okay, here's money, get my kid in, or cheat on this test to get my kid in, right? That's what just generally it sounds like. But there's more involvement.
That's what her mea culpa letter kind of sounded like. Look, I just wrote a check. He said he could get it in. I'm almost kind of a victim here because he preyed on us wanting to get the kids in, and I thought that it was okay, and then later I found out it wasn't and felt bad, so I didn't do it with my second child. Kind of that was the feeling that you get when you read these reports, but
I just don't want. I want to interrupt for one thing, just to make sure, Todd. I'm sorry to interrupt, but I want to make sure we understand this is what they're claiming.
So this is the
government.
document. So when somebody pleads, okay, they plead guilty, and the judge is going to issue a sentence. What happened was the prosecution wrote a sentencing memo. Judge, this is what we think needs to happen. And then Felicity Huffman wrote that letter to the judge about her mea culpa and accepting responsibility. Well, the prosecution had an issue with that because they thought that she was trying to paint it a little too rosy in her behalf. So they filed a supplemental sentencing brief saying, Judge, this is what she pled to. These were the facts that supported what she pled to, and she has pled. Okay,
gotcha.
And the government or the defense didn't come in and say, well, that's not what she did. So this is what they were prepared to produce at trial and what she pled to, which was first, they got her notes off of her PC, her laptop computer, the notes that she took when she met with Singer, the guy who was the mastermind behind all of this. And they found in the notes, first she wrote down $15,000 for a passing grade, $75,000 for a perfect grade. She also, in her notes, indicated that you only get to take the test a certain number of times, and if you take it more, it will tip them off, and you will be investigated. So she knows that this is something that can be investigated. And then after her last meeting with Singer, there were things that she had to affirmatively do. First, she had to contact the school and insist that her daughter be given 100% extra time. She then directed a psychologist to write a letter to the school to justify the extended time. She then filed an application to switch the testing location from the school to the location in West Hollywood that was controlled by Singer and his associates, where the proctor could doctor the answers. Then when the school said, no, we're going to provide our own proctor, she emails Singer with the, quoting Shaggy from Scooby-Doo, "Rut-row." Yeah. She says, "Rut-row, looks like the high school wants to provide their own proctor." So she knows that is a wrench in the plans of what they've got going. So then she has to lie to the school. This is, again, in the sentencing memo. It says that she then lied to the school and said that she had to take the test in West Hollywood because they would administer it over the weekend. But if she took the test at the school with the 100% extension of time, allowing the test to be taken over multiple days, that her daughter would have to miss school, and she didn't want her daughter to miss school. Ultimately, that's where it got. And so the prosecution put this forward to say, Judge, it was more than just He came to me, said for 15 grand it could happen. I wrote a letter, and that's pretty much all that I did. They put out there that she was an active participant in this plan.
Gotcha.
And so that's what happened. Still, they wanted 30 days with her, and the court ordered her to do 14. Recently, there were a couple of stories that were, oh my gosh, she got out on 11 days. See, the rich get over on people one more time. Well, when she got 14 days, she already had 2 days credit when she got arrested. So they take that off the 14. She had 12 left to do. And depending on how you calculate it, in federal prison, you get 85%, or you do 85% of the time. It's called good time credit. It's an incentive for people not to be idiots in jail. She got the same credits as anybody. It's somebody that is on welfare that got sentenced to 14 days federal prison and had 2 days credit because of the arrest would have done the exact same amount of time as Felicity Huffman. She got no benefit because of that.
But she did get flyovers and helicopters spying on her, and
She did.
the paparazzi taking pictures of her, working and doing stuff inside the prison, which I don't know. I don't think it's right.
The thing, though, that I see, Fred, you talked about this table that I downloaded that we
Yes,
found,
I'm
right?
looking at it right now.
And I'm noticing a pattern here of the government asking for very heavy-handed sentences, Felicity Huffman notwithstanding, and the court heavily undermining those recommendations. So they wanted 30 days for Huffman. She got 14. That's probably the closest in terms of the difference between what the government wanted and what she was ultimately sentenced to. The guy that we talked about earlier, Vandemore, the sailing coach that got no time, the government wanted 13 months prison for him.
Oh, my gosh.
13 months prison for a victimless crime, the only one that was truly victimless, that the only thing that really happened was the school got money for their program. They wanted 13 months for that. The court gave him credit for time served, 1 day incarceration.
And that's the scary thing that I worry about is the government. And here's a quick example. These rich people, because they're rich, and I'm not trying to stick up for the rich, because it's just the ones that you don't hear about get exactly what these guys got from the judges. Oh, that's not enough. Ready for this, everybody out there? The California Supreme Court in 2011 said that there's too many prisoners in California, it's overcrowded, and told them to release 33,000 prisoners.
Yeah.
And by the way, from 2011 through 2013, tens of thousands of those thousands and thousands of prisoners, thieves, people who've done all types of,
Sexual offenders.
yeah, were released, and they're out in our system now. And so when you sit there and argue, and again, I'm not jumping on the sides what they did was wrong, but to say, are you worried about Huffman going out and breaking into my home and stealing? I'm not too worried about that. Did she do something wrong? Yes, she did. But don't forget, everyone out there, there's some states that are just releasing prisoners left and right because they're overcrowded. Why are we sticking them in jail? That's what I'm saying.
It's the heavy-handed mentality that actually leads to that overcrowding. We talked about the Abbotts last week.
It's the rules like the 3 strikes where you have no choice or discretion as a judge.
Right.
Right?
Right.
I mean, that's what it comes down to.
So
we have overcrowding.
Yeah, the Abbotts, the government wanted 8 months apiece for those two. 8 months per individual. The court gave him 1 month per individual.
Right.
Now, here's the thing. The prosecution allowed, in this case, these folks to plead and allowed the court to determine what the sentence was in terms of the amount of jail time. Right? And I get that. But often, most of the time, in the cases that I deal with, the prosecution doesn't agree to that. The prosecution gives an offer with the total number of days jail set. And if the prosecution had come to these folks and said, look, the sentence is 8 months prison, okay? 8 months prison. And they said, no, I want to fight it. Now they're going to be in the same spot as Loughlin. They'll be facing not only their original charges, but they'll be facing the bribery charges. And because they didn't want to spend 8 months in jail, they're looking at something that could land them in jail for 5 years.
And Todd, especially when she saw how she looked in a prisoner's uniform, Martha Stewart said she looked schlumpy.
Yes. Yeah.
For 8 months, she's going to look schlumpy, and she's an actress. She's not used to that.
And the fact is that what they're going to end up doing is if somebody had not taken this deal because the government said, we want 8 months and we're not offering a range. We're not going to let the court decide. And they said, okay, we got to fight it. We don't want to do 8 months. Then they'll go and they'll end up starting it to go to trial. The government will amend the complaint to add the bribery charges. Now they're looking at double-digit number of years. And guess what the folks end up doing? They plead and take the 8 months. So now the heavy-handed thing has gotten them for 8 months. It's crazy.
Really quickly, we got to say it. And I know I don't want you to cut you off, Denise. You said something, but let's.
No, we got to talk
Lindsay,
about Buckingham.
Really quick, what did she get?
She got 3 weeks prison time. She is an author, book author, and she was active. She actually paid, I think it was $35,000. And was agreeing to a $50,000 payment to Singer, and she was going to have her ex-husband pay the $15,000 balance, and he refused to.
And she got 3 weeks in prison, $40,000 fine, and a supervised release for a year.
And the government wanted low end of guidelines, which would have been a minimum 3 years.
Yes.
Crazy.
Well, these are non-violent offenses. I think we all have to stay focused on the fact that they're non-violent offenses.
All right, we're going to be back next hour.
Go to the website, radiolawtalk.com. That's radiolawtalk.com.